Hey everybody, John Collins here. Welcome back to another edition of Crime in the Courtroom. Hope you had a great Labor Day. Today is Tuesday, September 2nd, and we got a lot to talk about today. There's a lot going on, and I'm going to be following up with you on a couple of things that I've talked about in previous episodes that for a variety of different reasons, I think are worthy of conversation to at least continue that conversation and learn from some of these really interesting legal, judicial, and scientific topics that make forensic science so interesting and make the use of scientific evidence in the courtroom very, very interesting. There's a couple of themes that we're going to discuss today to give you just a little bit of a heads up. The first question that we're going to answer is, can judges control what experts say during their courtroom testimony? In other words, during the evidentiary hearing, can the judge sort of negotiate, or is it appropriate for judges to negotiate with the trial attorneys with regards to what the expert will be permitted to say or will not be permitted to say? This is a very, very important question because it's coming up more and more in the forensic sciences, where expert witnesses are finding that during evidentiary hearings, possibly Daubert hearings, that the experts are feeling controlled by the judge or certain judges. And so we're going to address that topic, and we're going to actually look to legal and judicial precedent for some answers about that. So particularly for those of you that are expert witnesses and you found yourself in this situation, or you're concerned that you might find yourself in this kind of a situation, I'm going to share with you some thoughts on how you might be able to handle it and think about it. The other thing that we're going to talk about is what I would like to describe as sort of the nuclear option with regards to the power that judges could potentially wield over the forensic science industry if they ever chose to. And I think it's important for those of us that care about scientific evidence and care about forensic science and the future of the profession of forensic science to be aware of this, because we do not want to dismiss and we do not want to discount the influence that judges could wield on our industry, on the industry or on the occupation of forensic science. And so we're going to talk about that, and we're going to talk about the fact that they have a right to do it. And it's not something that has been discussed, at least to my knowledge, in the forensic conferences that I've attended and in the interactions that I have with individuals, both inside and outside of the forensic sciences. So we got a lot to talk about. It's going to be an interesting episode. So let's jump right into it. First, I want to begin, as I always do, by thanking my good friends and colleagues at Promega, host of the International Symposium on Human Identification, which is the largest conference in the world dedicated to the practice of forensic DNA testing. As we have mentioned, the symposium this year is in Palm Beach, Florida, which is going to be from November 3rd to November 6th of 2025. And in our previous episode, you heard me having a great conversation with my friends and colleagues, Julie Sikorsky, Pam Marshall, and Ray Wickenheiser, about our Forensic Leadership Alliance, which is a program that is affiliated both with Promega and with the ISHE conference. And so we're going to be doing a half-day workshop on the Thursday of the symposium, but we also pointed out that we're going to be doing one-on-one mentoring and coaching sessions on that Monday. So again, you can email me directly if you're interested in a coaching session with me or any of my colleagues. You can email me at office@criticalvictories.com, office@criticalvictories.com. And if you'd like more information about the ISHE Symposium coming up this November, and my gosh, it's right around the corner, time flies. You can visit ishinews.com. That's ishinews.com for more information. I do have, and I'm going to have more information about this in an upcoming episode. We're getting close to the end of the season, and so I'll have more about this. One of the things that I didn't share with my viewers and listeners when we did those two episodes on the Oregon appellate ruling, which which rejected the comparison of cartridge cases or the identification of fired cartridge cases as having originated or been fired from the same firearm. And so we had a lot to say about that. And then we went on to discuss further a lot of the implications and talking about Daubert and the federal rules of evidence and the nuances of of evaluating scientific evidence or the reliability of scientific evidence when you are not a scientist and when you're a lawyer or when you're a judge. And so we went through a lot of those issues, and we're gonna build on those a little bit today. One of the things that I didn't mention was that for some time I had been working on a manuscript, coming close to the end of a manuscript for my next book. And the title of the book is Valid Comparisons: The Forensic and Judicial Interpretation of Stochastic Patterns. So you remember we talked about stochastics as being the science of randomness, more or less. And because of the response that I got from those two episodes, I felt compelled to reach out to my publishing house to let them know that I wanted to fast track this manuscript. We were shooting for a late 2026, 2027 release of the book. I'm far enough along in the manuscript that what I decided to do, because of the issues that are in play and the things that are on people's minds and the things that they're worried about when it comes to expert testimony, and particularly the comparison and interpretation of these random stochastic patterns, I just more or less made a business decision that I wanted to fast track the book. So this is my first public announcement of of my next book, Valid Comparisons: The Forensic and Judicial Interpretation of Stochastic Patterns. I am extremely excited about it. I think it's going to provide great support and encouragement and some nuanced understanding, enhanced understanding for our forensic practitioners out there that work in the stochastic pattern fields: firearm and tool mark identification, latent prints, shoe and tire impression, forensic code ontology, bite mark analysis, handwriting analysis, and others. And so what this book does is it helps to bring together in a scientific way uh, these these different disciplines. Now, nothing about what I write is intended to change or suggest that things need to be changed in the way that these disciplines practice, or that somehow these disciplines can't be independent anymore. They certainly need to be, because they're completely different areas of practice, but they are unified together under a common scientific framework. And I'm going to lay out the history of that, or I do lay out the history of that in this book. So I'm going to have additional information for those of you out there that are interested in kind of getting some excerpts and some sneak peeks of parts of the book, Valid Comparisons. And what I am hoping to do is to be able to have this released in print form by February, so early 2026. So we're fast tracking this. The publishing house that I work with is aware of it. We've got a lot of graphics and photographs that are going to be incorporated. Which reminds me, for those of you that work in the forensic science laboratories out there, if you are able to provide me with some good photomicrographs or photographs of these comparisons that you do of these stochastic patterns, latent prints, or any kind of friction ridge print, bullets, cartridge cases, handwriting. In other words, you feel that you've got a good photograph that you can share with me, I will incorporate it into the book and I will give you credit in the book for the photograph. You just need to let me know who needs to be credited, whether it's you personally, your laboratory, or you and your laboratory. I prefer it to be the scientist and the laboratory. So I will include these in the book. I have some photographs that I'm including from back in my days when I was working in the firearm and toolmark unit. But I would love your support and assistance to help me provide some graphics to include in the book. So I'm going to have more information for you as we roll this out, and I'm also, as I said, going to have sort of a channel that you can stay in touch with me and get excerpts and teasers on the book as we get into pre-production phase and or pre-publication phase, and then we get ready for the final release. And I do anticipate that we'll do an audiobook version as well, but I'm a little uncertain on that for right now. So anyway, it's an exciting project. It's something that I've actually been working on for the better part of about 15 years. And so being able to sort of return to my forensic scientific roots and produce this book is very satisfying, very exciting for me. So I'll have more information about that as we get a little bit closer. When it comes to the the role of judges in the evaluation of scientific testimony, scientific expert witness testimony, it all comes down to trust. One of the frustrations that I voiced in the previous episode, and it's something that I discuss a little bit further in the book Valid Comparisons, is that there has been a chronic and pervasive mischaracterization of what science is within the American criminal justice system. And it is especially prominent, or these messages are especially prominent from individuals that appear to more or less fancy themselves as being activists or commentators that critique forensic methods. And as we talked about earlier, one of the things that came out of the Daubert ruling in 1993 was a misunderstanding about the potential for error in science. So the Daubert ruling was actually quite important, and it's good that it came out. And the reason is because it sent the message to the federal courts, and certainly this reverberated beyond the federal courts into the state courts, was that Fry doesn't matter anymore, or at least it doesn't matter the way that it used to. And the reason for that is because in 1975, the United States Congress, which was signed by President Gerald Ford, signed the Federal Rules of Evidence. And so this was just ahead of the bicentennial anniversary of the United States. There was, centuries of legal precedent and best practices that the Supreme Court decided that should be codified. And so the Federal Rules of Evidence were passed into law. It's not just a guideline. It's not just a how-to manual. It carries the force of law because it is law. And one of the rules of evidence is Rule 702, which deals with the the testimony of expert witnesses. And so what Daubert did, it did a number of things, but what Daubert was essentially doing was it was reminding the federal courts that you have to follow the federal rules of evidence. You have to stop it with the Fry stuff. You follow the federal rules of evidence. And this, of course, invited additional questions because what the federal rules of evidence do is they basically map out more or less a thought process for evaluating scientific testimony and making sure that the results are reliable, that it can be trusted. It's all about trust. You can micro define science, or you can narrow down your definition of science to meet whatever social or political objective you may have. But ultimately, it comes down to trust. We have an expert witness that has drawn a conclusion that matters to this court. Can we trust it? That's it. It doesn't get much more complicated or much easier than that, even though a lot of individuals out there like to overly complicate it and they like to define science very narrowly because they're trying to keep some out and keep some in to meet their own purposes. And that's a rhetorical device. That's not scientific. So this tr this trust thing is extremely important in science because that's what science is. It is a framework of thinking and experimenting so that you can answer consequential questions and you can solve consequential problems in a way that is trustworthy. And there are many different ways that you can achieve trust in science. So the idea that there's this recipe or this strict process that you have to follow is just not true. Okay, science comes in a lot of different forms, and there's a lot of different ways, even within a single scientific framework, to establish what we call validity. Now, going back to the Daubert ruling, the Daubert court created or set forth five provisions, as we talked about earlier. And one of those provisions created literally decades of confusion. And that was the provision with regards to error rates. And the error rate provision, in a lot of ways, was what made Daubert so historic. I think if you had taken out that error rate provision, Daubert would not have had the splash that it did. It still would have been consequential from a legal standpoint, but from a scientific standpoint, it was the error rate provision that really, really rankled a lot of feathers, and it gave ammunition to critics of forensic science who used that as a way to discredit the most commonly practiced forensic methods, including the comparison of stochastic patterns. So this was important because these critics spun that provision in a way that was never intended by the Supreme Court. All the Supreme Court was trying to do was to help these judges act in their gatekeeper role and to follow the federal rules of evidence, more specifically Rule 702. And so all the Supreme Court was saying in Daubert was that if you have a particular area of practice or you have an expert witness that comes from a particular discipline or area of expertise, it can be helpful to judges to consider any known rates of error. Okay, so you could have a doctor that's testifying as an expert witness that comes from a hospital, and that hospital may have known rates of infection, or they may measure the number of fatalities within 30 days after discharge, different kinds of statistics. So there are ways that, you can measure error. The critics of forensic science were not stupid. They understood that error rates are arguably impossible to fully establish statistically into a neatly packaged rate of error. And so what they did is they said, oh, look, they threw their hands up. These forensic disciplines, they don't have known rates of error. That means they're non-scientific and they should not be permitted to come and testify to their garbage in our courtrooms when people's lives or people's freedom and potentially lives are on the line based upon that testimony. It was a complete distortion of Daubert. And what this perpetuated, as I talk about in my book, was what I've described for discussion purposes, the Daubert contagion. This contagion, this mischaracterization of error in science spread like wildfire and fueled much of what came later on down the road, which was the NAS report in 2009 and then the PCAST report in 2015, which were heavily critical of forensic science. And there's a lot to those reports. I touched on them just a little bit in those previous episodes that I talked about earlier. But this contagion spread, and what it did was it essentially gave ammunition to critics, activists, advocates, whatever you want to call them, to perpetuate claims that these most commonly practiced forensic disciplines were not reliable. They were not valid, which was a gross distortion of the truth. And that is easily demonstrable. That's easily demonstrated. As you got later into the 1990s, as you know, the wake of Daubert in that decade, we started to see some really interesting things happen. Two of the most consequential that some of you may not know about, and this was something that I didn't fully appreciate until I got into the meat of the manuscript of my book, was a case, United States versus Mitchell. And this was a hearing or a case that involved a Daubert hearing that covered the analysis of friction ridge patterns or fingerprint or latent print comparison. And this was this was a ruling that helped to give rise to what became known as the ACE-V method in latent print vernacular. ACE-V is an abbreviation for analysis, comparison, evaluation, and verification. You could argue, and I think it's fair to argue, that that methodology applies to the comparison of any of the stochastic patterns. So this was a framework that latent print examiners came up with to sort of describe what they do, and it was a tactic, I think, a reasonable and effective tactic to manage the affairs of the discipline in the wake of Daubert. But what you had shortly after that, about 5 years later, was the famous Brandon Mayfield case, which was the result of the investigation of the Madrid train bombing in 2004. And so Brandon Mayfield was a gentleman that was erroneously identified as having left a fingerprint of investigative significance in that case, and as it turns out, it was erroneous. It was a false identification that occurred at the FBI laboratory, and I just so happened to have been serving on the board of directors of the American Society of Crime Laboratory Directors when the quality manager of the FBI lab came to our board to explain what happened. And when you do an honest assessment of that case, what you find is that although the Mayfield case has been spun in various circles as a failure of science, it was not. It was not the science that failed. It was a cultural failure. And it was a cultural failure that the FBI, to their credit, readily acknowledged. And I'll just inject this because I happen to be an individual that thinks very highly of the FBI and especially the FBI laboratory. And um, I don't think I think most of us in the criminal justice system and I'll say also specifically the forensic science community have an ounce of a clue as to how much pressure our colleagues at the FBI are under, and the administrative and the cultural and the legislative pressures that they deal with every single day, all while trying to keep up with the cases that are coming into their laboratory. And so one of the things that contributed to the Mayfield incident, or the erroneous identification in the Mayfield case, were cultural pressures. And if there's anything to take away from the Mayfield case, it's not so much that there are weaknesses in the science, although all science has the potential for error. It's the impact that cultural dynamics can have on the practice of forensic science. This is going to become relevant as we get a little bit later into the episode here. So, what does that mean for us? Well, what that means is that rates of error in forensic science are not of value. What we have to be thinking about in forensic science is vulnerability to error, or error vulnerability. And this is important because when you're talking about error rates, what it does is it presumes the existence of some kind of statistical framework in which the potential for error can be quantified. as some sort of statistical value. Okay, so we can't do that in forensic science. Okay, what we do in forensic science is we focus on on error vulnerability. It is a subject, a topic, a theme that you explore through conversation and through the asking of questions. You discuss it. And so if you're an attorney and you're cross-examining an expert witness, error vulnerability is a much, much more effective line of questioning than error rates. You can try to convince a jury or a judge in an evidentiary hearing that that a particular forensic practice is not valid because there's not a known rate of error. Yeah, you can try that, but it's a completely fraudulent and intellectually dishonest line of inquiry. The more honest and constructive line of inquiry, which also has the potential to reveal actual weaknesses that could have in fact impacted a particular analysis or a particular item of evidence that's of consequence to the court. Error vulnerability is a much more relevant topic for us. So the Daubert contagion was really, really devastating on the scientific side because it fueled misconceptions about what is actually important in forensic science, and that is error vulnerability, not error rates. Now, for those of you out there that say, well, John, you're misspeaking here because DNA has known rates of error. They use all these fancy statistics and all this. No, that's incorrect. DNA has no more ability to assess rates of error than firearm and tool mark identification or latent prints. What our friends in the DNA community use are what are called population frequencies. These are scientifically validated and established frequencies that we would expect a DNA profile to have in the population. So essentially, what it allows DNA examiners to do or DNA analysts to do is to estimate for the jury, for the judge, for investigators, the chance that you would have two individuals with a particular DNA profile in a particular population. That all that is that's population genetics, genetic frequencies. If I'm not using the proper terms out there, uh, forgive me or shoot me an email at office@criticalvictories.com. But what we know is that DNA analysts need this data. They need this data to say, what are the chances that you would have two individuals with the same DNA profile? That's what they're doing. That is not the same as rate of error. It doesn't speak to the possibility of a mistake being made. It doesn't speak to the possibility of a sample switch. Doesn't speak to the possibility of contamination. Doesn't speak to the possibility that two test tubes were switched during the analysis. DNA analysts do not have known rates of error. Period. That's it. Now, are there studies being done? Yes. Are there studies being done in the stochastic pattern disciplines? Yes. We were getting closer, and maybe this is one of the good things that comes out of Daubert. But the question as to the cost effectiveness of these studies is up in the air because there's no there's no judge or attorney or jury that's going to be satisfied or should be satisfied with a forensic expert coming in and saying, yes, I identified the cartridge case at the crime scene as having been fired in this particular pistol, and the chance that I am wrong is 0.012%. Okay, well, any attorney worth their salt is going to push the expert to say, how do we know you're not in that 0.012%? And so now you're left with wondering, was it worth the cost to study these rates of error? Is it not more useful to have a conversation about error vulnerability in general? And the answer, in my opinion, is yes. So, in terms of respecting the gatekeeping responsibilities under Daubert and the rules of evidence that judges have. Because we do need to respect them, we need to appreciate them, and we have to recognize how challenging that can be for a judge who is a lawyer to evaluate science. Um, Paying attention to error vulnerability and recognizing that science comes in a lot of different forms and scientific validation comes through a lot of different kinds of studies. And I'm going to be talking about a lot of those different kinds of studies in my book. We always, as expert witnesses and people that care about scientific evidence and its use in court, we need to, from time to time, step back and think and reflect on the enormous responsibilities that judges have under Daubert and under Rule 702 of the Federal Rules of Evidence. Judges have every right to question or be suspicious of the reliability or trustworthiness of particular conclusions that will be offered by expert witnesses at trial, assuming the case goes to trial. So, to the extent that a judge holds some, like a motion to exclude or some kind of evidentiary hearing, then we have to respect the fact that for whatever reason, a judge may decide that he or she is just not convinced of the reliability of this conclusion. And so, therefore, it's going to be omitted. In other words, I'm not going to let the jury hear it. And if you're the expert witness and you're the one you're the one who has the conclusion that's being rejected, that's not a good feeling. It's sort of offensive. It's offensive to your professional sensibilities, because the ultimate presentation of your results in court is why you exist to a large degree. So that's not a fun thing to have happen. And I've had, in my forensic career, I've had instances where I had professional opinions based upon my analysis, and I was not permitted to testify. Now, one of the reasons, and this is important to keep in mind, that there was one case in particular where I was not permitted to testify on a conclusion that I had reported to the police and prosecutors through our laboratory testing report. It was not because of a lack of scientific validity or because the judge felt that I did something wrong in the case. It was actually because the context of the case, the nature of certain testimony that was going to be coming out in the case created an elevated level of risk for the jury to become confused. The judge felt, as I recall, and this goes back over 20 years, the judge felt that my testimony was just not useful to the matters that were being resolved by the court. Because remember, that's one of the prongs of the Rule 702 is that the testimony has to be of use to the trier of fact in resolving the dispute before the court. And so there was a potential for confusion, so that's why it was omitted. But one of the things that I was reminded of after I did those two episodes on stochastic patterns and on Daubert and the NAS and the PCAST report was the fact that there are some judges out there who, when considering expert testimony, are during evidentiary hearings, let's say, are listening to what the opinions of the expert witness are. They are unconvinced that the expert is able to give the conclusion that he or she wants to give at trial, but for whatever reason has decided that the judge decides that he or she does not want to prevent the witness from testifying. In other words, the judge is of the opinion, for whatever reason, that I don't believe you, Mr. or Mrs. Expert or Mr. or Ms. Expert, but I want you to testify. I don't want to deprive the jury of the opportunity to hear your testimony. However, I'm not going to let you say certain things, or I'm not going to let you say something in a particular way. And so what happens is we have these instances where judges attempt to micromanage or control the testimony of the expert witness. And this is of very, very serious concern to a lot of forensic laboratories out there, forensic laboratory scientists. How do you handle the situation? Is it even permissible? So I want to give you some thoughts on this, and this is going to probably be something that I'm going to talk more about in my expert witnessing class, because it's on so many people's minds. As as a general rule, if we look at Rule 702 of the Federal Rules of Evidence, if we look at Daubert, okay, expert witnesses do not just come to court to deliver a particular conclusion, right? Although they do that, that's not the only reason that expert witnesses are called to testify. Expert witnesses are called to testify because they are recognized as having sufficient levels of expertise in a particular field or occupation or area of professional endeavor. The judge cannot predict all of the questions that the attorneys are going to ask. So when an expert witness is permitted to testify, they are tendered as an expert in a particular area. They are not tendered as an expert in the delivery of a specific conclusion. Okay, so again, I'm speaking generally here. So for that reason, it it is improper for a judge to micromanage the testimony of an expert witness, or to try to pare down what the expert witness would testify to if asked a particular question. Now, where this comes into play is particularly with identifications, which has, when I first got into the field, this was not even a subject that anybody really cared about. It was just sort of it was the standard practice, right? So if I identify a bullet as having been fired from a particular gun, we'll use that example. Um, the the offense that people take to that is that they they view it as a statement of certainty, incorrectly so. And this is really important for those of us that function on the expert witnessing side. They will say that the identification is a terminal conclusion because it allows for no other discussion. In other words, when you identify a bullet as having been fired from a specific gun, what you are saying is that there is no other explanation for how that pattern of stochastic pattern of marks appeared on that bullet. The only way that that pattern could have gotten on that bullet is to have been fired from this gun. So people perceive it as being certainty. And you can hear people talk about this that criticize the use of the term identification. Okay. So what are you to do with that? Because there's a lot of you out there that identify patterns as having been made from a particular source, or you identify a source as having made a particular stochastic pattern. Could be friction ridges, cartridge case, bullets, handwriting, and whatever it may be. I am of the opinion that expert witnesses in the forensic laboratory sciences should reject being micromanaged. And I would encourage you and even urge you to stick with the reporting of identifications. And I want to tell you specifically why that is. So when the identification is an answer to a question, that's what forensic science is. It is a business of answering questions of investigative, legal, or judicial significance. If you conduct as a appropriately trained or qualified firearm and tool mark examiner, for example, and you go into court and you are asked the question of the attorney, Mr. Collins, were you able to identify the firearm that was submitted to you in this case as having fired the autopsy bullet? If I am asked that question, and based upon my professional experience and training, and in alignment with my laboratory's procedures and my compliance with my accreditation standards and my quality assurance practices that are established in the lab, if it is my best professional judgment that I have identified the gun that fired the autopsy bullet, then it would be unethical for me to not state that when asked under oath. Period. This is one of the things that you come to learn when you specialize in the comparison of stochastic patterns, is that you reach and then cross a threshold where you know that you have, or actually, I should rephrase that to be a little bit more scientifically fair. You reach such a high level of confidence with such minimal doubt that that gun fired the autopsy bullet, to use that example, that you have identified the gun for all practical purposes. And so to not say that or to not share that when asked would be inappropriate. So then the question becomes, well, then why do you put that in the report? Why is it in the report that you say, People's Exhibit 3 was identified as being fired from the firearm, People's Exhibit 12? Well, it's because in forensic science, we anticipate the questions that we're going to be asked. And if you're a firearm and tool mark examiner and you receive in the laboratory a bullet from the autopsy and you receive a suspect firearm, it's a pretty safe assumption that you're being asked to determine if you can identify that gun as having fired that bullet. Why else would they submit it? So I happen to be an individual, an experienced and I dare I say credentialed individual that believes that this push that exists under the radar to stop forensic scientists from reporting identifications, identifying the source of stochastic patterns, is unethical. And for judges to limit the testimony of expert witnesses and to suggest that they cannot answer the question according to what they know to be true is also unethical. It is inappropriate. And you laboratory administrators out there, my colleagues, laboratory directors, unit supervisors, do not relent to judicial manipulation, to the judicial manipulation of how your scientists testify. Now, is this happening at scale? Is this happening frequently? I have to be honest with my audience here that we know that it's happening, but to say that it's happening frequently, I think might be unfair. I think the vast majority of judges out there are very reasonable. They understand the basis of the science. They understand the error vulnerabilities that exist, but they understand that the existence of error vulnerability does not invalidate a particular scientific practice. Okay, so so there's that issue. I am a big proponent and supporter of the stochastic pattern disciplines in forensic science. The identification is one of the most important legal, investigative, and judicial findings that we issue in forensic science. And to water that down or to suggest that it's not valid or it's not fair, that's spin. It's political spin. And we know through experience and training and research and experimentation that has been compiled and accumulated over a century that these are valid sciences. These are valid comparisons, as the title of my as the title of my book says. Now, so I'm glad to have had the opportunity to address that. There's one more. I like to call this the nuclear judicial option that I think many of us in the forensic sciences and those of us, as I said, that care about scientific evidence in courts of law that we haven't contended with and we haven't talked about. And I think that there is the potential that this could happen. I have always been, and I was in those two episodes that I discussed, critical of the National Academy's report, Strengthening Forensic Science in the United States, A Path Forward, which came out in 2009. It was a committee that was funded and managed by the National Academy of Sciences, and then the report was published by the National Research Council. This all falls under what's called the National Academies. And the and one of the reasons that I'm critical of the National Academy's report is because it just was not a realistic exploration of science. They tried to cover so much stuff and they overshot and they mischaracterized the forensic disciplines. They ignored research. The and they gave credence to information that itself was not validated. They just accepted blindly that the claims of the Innocence Project about the frequency that flawed forensic science leads to erroneous convictions. They just accepted that. So so right from the start, they did not present themselves as serious investigators into forensic science. But the thing that was interesting that, and for those of you that take my expert witnessing class or have taken my expert witnessing class, and if you're watching the video, I'm going to hold this up. This is a book. It's titled On Being a Scientist. I've had this in my library since 2009. Coincidentally, this report was published through the National Academies, the same organizations that published the 2009 report on forensic science. And when you read this little booklet, see, it's kind of thin. When you read this booklet and you absorb what the authors describe as the elements of good science and the elements of being an honorable, competent, trustworthy, ethical scientist, and you take the principles in this book on being a scientist and you overlay those with what was reported in the 2009 report on forensic science, they're not even remotely in the same ballpark. You can see when you look at what, and this is really one of my, I refer to this quite often. When you look at what are truly the elements of science, and then you look at the very, very narrow and conveniently tightly defined definitions of science that were propagated by the National Academy of Sciences Committee on Forensic Science, you can just see that the report was heavily compromised by existing biases that, in my opinion, were fueled by the Daubert contagion. And so that being said, it would be dishonest to suggest that there was nothing of any value in the National Academy of Sciences report of 2009 because there certainly was. The report was pretty accurate and pretty effective at explaining some of the cultural and infrastructural challenges that forensic science laboratories have, coroner's offices, medical examiners, things of that sort. And one of the things that the NAS report of 2009 recommended was the administrative and cultural separation of forensic science laboratories from their parent law enforcement agencies. And this has been a topic that I've covered in a variety of different contexts over the years. I've spoken about it publicly and workshops and different kinds of speeches that I have given. And the position that I think the responsible position that one takes on that topic is that there's nothing about a forensic science laboratory being situated within a law enforcement agency that means that it intrinsically must necessarily then be vulnerable to these undue pressures or these cultural challenges. So you can't necessarily say with 100% certainty that just because a crime laboratory falls under a law enforcement agency that it is going to be catastrophically compromised. And so the responsible position, I think, to take on this issue is to recognize the vulnerabilities that are presented with police culture and the impact that it can have on science, and then do your best to mitigate those. So before you simply say that we're going to just separate all crime laboratories from law enforcement agencies, you would have a responsibility to try to take the more cost-effective approach, which is to simply make these law enforcement agencies more effective at managing and supporting and funding their forensic science laboratories. Because if they do that, then you don't have a problem anymore. And I think it's safe to say that there are some really good really good, responsible law enforcement sworn commanders out there that oversee crime laboratories that do a very good job. So, so I think you have to be measured on that front. I certainly understand where the NAS committee was coming from and what their concerns were. I think those concerns are very justified because I know just through my own experience and through my coaching practice that there are a lot of forensic laboratory professionals and directors and supervisors that are coping with significant hardship that arises from dysfunctional police culture and the poor treatment of those laboratories by their law enforcement agencies. So I don't believe that there could or would ever be a mass policy-based separation of forensic science laboratories um, from police agencies simply by virtue of the fact that the NAS report said so or that anybody said so. In other words, it just doesn't seem like a good fit. As I was writing valid comparisons, I there was a part of this book where I was sort of forced to confront the issue and think about it a little bit differently. And there is a what I would call a nuclear option that could happen if you take into consideration everything that has happened since 1993, the Daubert ruling, the Daubert contagion, the NAS report, the PCAST report, the Innocence Project's 200 conviction report, which incorrectly blamed forensic science on for erroneous convictions. But if you take the whole package and you recognize that whatever you think about it, there's this lingering desire to have conversations about the trustworthiness of forensic science. That has not gone away, and it probably is not ever going to go away. I'd like you, for our purposes, to imagine that the judges themselves, that there was a national movement amongst federal and state judges in the United States to voice their displeasure or voice their dissatisfaction in the trustworthiness of the most commonly practiced forensic science methods. You know, we talked about the Oregon appellate ruling, and there's been other cases out there. The judges are the gatekeepers. That authority has been handed to them by the Constitution of the United States, but then more specifically the federal rules of evidence, and then the Daubert ruling, or the Daubert trilogy of rulings. If it was to ever come to pass that judges across the United States gave advanced notice and said, as of 3 years from now, we are no longer going to accept the testimony of forensic laboratory scientists who fall under the organizational authority of a police agency or of police commanders. In other words, if you are a forensic scientist and you go up your chain of command and there's an officer with a badge or a gun strapped to his or her belt, you're not going to testify in this courtroom. You would see an immediate and unmistakable and sustained effort to separate forensic science laboratories from police agencies, and it would happen quickly. There would be some labor issues that have to be dealt with. There's collective bargaining issues and unionized laboratories, so it's not an easy thing. But you would see it happen. Now, the question becomes is, would judges be justified in doing that? And look, there's a lot of judges out there that they scratch their heads at forensic testimony. You know, they get a latent print examiner that comes in and says, yes, I can identify this individual as having left this latent print to the exclusion of all others. And then the judge is looking at the photograph and it sees a bunch of smudges. Like, how the heck did you identify this, right? Right? There's suspicions. Judges are being asked a lot to trust some of the testimony that comes into the courtroom, even though it most likely is valid and legitimate and accurate. But on the trust front, which is what, again, that's what this is all about, to the extent that judges as a community, federal and state, decided that they had enough concerns about the forensic science enterprise that there was going to come a day when across the board they were going to agree that we are not going to permit the testimony of a forensic laboratory scientist that falls in a law enforcement agency. You would see a sweeping, fast, and massive restructuring of the entire forensic science infrastructure in the United States. Now, the question becomes, would that be permissible? Because if a judge in any particular case, as we talked about in the previous episode, it's when it comes to the role of the judge, it's specific cases, specific evidence, specific experts, specific testimony. So there could be the grounds for appeal that the judges were, despite this collusion or, whatever you want to call it, that it was inappropriate because parties at trial have a right to present evidence. They do. Attorneys at trial have a right to ask questions, and they have a right to have experts on the stand to answer those questions. And so would it pass judicial muster for judges to take that approach? That's open to debate. And having kicked this around with some colleagues of mine, the scenario, this nuclear option, is not without validity. It's not. Because if you give sufficient advance notice, and then a particular laboratory or a particular expert witness does not comply with that, then that in of itself can speak negatively to that expert witness's credentials under a 702 or Daubert evaluation. This is something that we've really never talked about in forensic science, the possibility of there being some kind of sweeping national movement among the judges to say, look, we're tired of this. We're tired of these debates about forensic science. We're tired of these reports that come out. But one of the things that we're concerned about is that these scientists that are coming to testify in my courtroom, they say they're scientists, they say they work in scientific laboratories, but they work for cops. And as a judge, I don't know if I trust scientists or if I'm going to be able to continue to trust scientists who report to cops. Now, is that is that unfair to the cops, especially the sworn commanders that are honorable, honest, and supportive of their laboratories? Yeah. Does it matter? Might not. This is a big issue. Um, I'm of the opinion that these little skirmishes that have been happening in the wake of Daubert on error rates and the role of forensic science and wrongful convictions and the NS report and PCAST, all these little skirmishes are leading to something bigger and more consequential than what we are aware of right now. And I don't exactly know what form that will take. And I'm not saying that I'm advocating for judges taking this approach, but there are circumstances that could arise that would force a massive reorganization of forensic science in the United States. And who knows, it could be a really bad thing or it could be a really good thing. But again, I've spent a lot of time here, just kind of wrapping up here. I've spent a lot of time the last several episodes talking about some of these issues with stochastic patterns and Daubert, and we'll continue to talk more about them. But the more that I think about them, and this is something that I'm going to be addressing in the epilogue of my book, which I'm actually writing right now, is that there's something much bigger that's at play here. And these little skirmishes are happening in the weeds of the forest. And if we draw our focus out so that we can see the forest for the trees, I think what we're going to find is that all of this is leading to something much more consequential. And I believe that that will include, in some form or fashion, an evaluation of the relationship between forensic science laboratories and law enforcement agencies. I'm a supporter of law enforcement. I'm a supporter of forensic science. I coach people and train people in crime labs and law enforcement agencies. I've coached chiefs of police. I've coached sworn law enforcement commanders, and I know the challenges that they're under. But forensic science is just these forensic science laboratories out there that I care about so much. They have become so much more advanced, even since I got into the profession, but certainly since 1980, when the Illinois State Police became the first accredited laboratory system in the United States. They are so advanced. And so the cultural imperatives that that exist in forensic science when you compare them to policing are you just cannot deny that they are diverging. And so the appropriateness of law enforcement being in charge of forensic science laboratories, I think, is going to be a subject of discussion for many, many years to come. I think in forensic science, we need to think about these things, or at least be prepared if we are positioned to have to make some of these national occupational um, structural changes to the profession. And again, will that happen? I don't know, but I think for our purposes, it's interesting to think about. And I think these kinds of issues, I don't think should burden any forensic scientists. I don't think they should burden laboratory directors, but I think what they should do is they should inspire all of us to want to be the very best that we can be, to be the impeccable, consummate expert witnesses and scientists that we can be, and to be advocates for the truth. Um, Truth about the limitations, the strengths and limitations of our own scientific practices, the truth about the strengths and limitations, about the arguments of our critics, the people that argue that forensic science is not valid or it's understudied or whatever it may be. Forensic science is a profession that needs real serious people that are committed to the serious work that is forensic science. What I'd like to do here, just in closing, is I'd like to read to you an expert or an excerpt, excuse me, that comes from On Being a Scientist, and I think that this is just a really nice way to wrap up this episode and to think about science and its importance to the world. So this comes from the preface of the book. Quote, "The scientific enterprise is built on a foundation of trust. Society trusts that scientific research results are an honest and accurate reflection of a researcher's work. Researchers equally trust that their colleagues have gathered data carefully, have used appropriate analytic and statistical techniques, have reported their results accurately, and have treated the work of other researchers with respect. When this trust is misplaced and the professional standards of science are violated, researchers are not just personally affronted, they feel that the base of their profession has been undermined. This would impact the relationship between science and society." End quote. So again, this comes from third edition On Being a Scientist, which was published by the National Academy of Sciences, the National Academy of Engineering, and the Institute of Medicine. You can find this online. I love having this little booklet in my library because it reminds me that despite all of the political skirmishes and the social activism that surrounds the criminal justice system and forensic science, and particularly as it relates to overturned convictions, that when it comes down to brass tacks and when we distill it all down into its simplest terms, science is not such a complicated thing. And when it's practiced in the hands of honorable people with integrity that have the facilities and the equipment and supplies and the expertise to do that work right, we will be better off trusting them more so than we would be than distrusting them. So these forensic disciplines that have been around for so long, they're not reliable because they've been around for so long. It's because what happened while they were around for so long, the work that was done, the experience that was gained, the research that was done. And you can pretend that it doesn't exist if you're one of those critics out there, and you can come up with a bunch of interesting, even faddish, popular critiques about forensic science that gets people's attention. But I'll tell you what, if it's your loved one that is shot and killed, and a fingerprint or a shoe impression or a bullet identification can help your family um, understand how your loved one was killed, I think you'd think a lot differently about this occupation that you've spent so much time critiquing. But I guess we all have our place and we all have our roles. And I wish everyone the best. So we're getting close to the end of the season. I think right around Thanksgiving time. I've got a lot of interesting stuff to share with you. Thank you for joining me. And as always, I hope you found this episode enlightening and maybe helpful in building your own expertise and whatever it is that you do. And again, I hope to see you at the issue meeting in Palm Beach, Florida, November 3rd to the 6th. And we'll see you for the next episode of Crime in the Courtroom. John Collins signing off. Thanks, everybody.